was not
No,
well.
it's now assigned to me.
Yes, my lord. My lord,
Tied up.
it's a tied up matter. It already disposed of by
When the
this.
date is now fixed.
My lord, actually, 10/2. February ko ହେଇଯାଇଛି.
You might not have appeared.
My lord, actually, I was having sore throat and fever.
Nobody
that day.
requested, so that therefore I thought you are not interested.
Associate was there, but he somehow, my lord, I apologize.
Matter will take.
Again, what memo
We'll
devi
see.
ଦେଇଦେବି.
We'll
Okay, fine. Grateful, man.
L matter my lord last week 4 तारिख रे लिस्ट थिला अन्य को अक्यूज मानकर 10 तारिख को हला यार जेतु कैंसर यार स्पेसिफिक इंस्ट्रक्शन आनिया पई कहिथिले सेही 10 तारिख आसिया पई कहिथिले भूल ले सेटा 8 जनवरी हे जाईची डेटटा ऑर्डर रे देखि हां से काली आसीओ अन्य को अक्यूज मानकर मैटर सब काली के आसी
देखियो I don't know what will happen tomorrow. Nobody knows.
I was pardon to mention your items.
And it may so happen that tomorrow's matter will also go on that day. No.
I must pardon to mention your item 64. Mr. Mishra, you have some personal difficulty. I pray kindly taken first week of January.
64.
64. I have concern from the other side also.
Pardon me, Lord.
First week of January.
Hello. He'll adjust it. I will not give the date.
All right.
Well, item 61, Lord.
61. Yes.
61, Lord, is a compromise matter. Optional under section 376, Lord. Earlier, last date, this was stated, my lords. So, झियो आज्ञा बाहर से recently बाहर बैंगलोर जाइथिला मु हजूर पर प्रेयर करथली से विषय जॉइन करियो बोली हजूर कहिथिले तो आज अछि सेटा
Yes, I'll take it up at 12 o'clock.
12 o'clock 376
She has
informant appeared, my lords.
She is married with someone else.
Married, my lords. No, with compromise.
Has he filed the affidavit here?
Affidavit, my lords, one file.
We'll examine it. Just see.
My lord, no problem, lord. And he will join in this, lord.
We'll see.
My lord.
My lord, criminal revision, fresh admission, vigilance.
Belgium.
Madam.
Belgium. कल लगा दो यार Belgium.
my lord item 63
हाँ? Belgium. कल लगा दो यार.
my lord item 63 I am praying for adjournment for petition obliged
Yes.
50 to start
50 to start. 58.
58
58. What is this matter for?
Proceedings is special for that will be the 5 notification. They have to file an appeal or a deed. Then because of the specific part.
What to do? There is interim order. See, they are taking advantage of interim order. चलो जनवरी लगा दो यार क्या कर सकते
night
Yes. Non-appears in the interest of the February. There is no interim order. Let it go.
60
Yes.
Order of cognizance is on the telephone, my lord. And 37934 items. Was offer measures. Then was conductor, helper, and that person.
What are the grounds?
Ground activities they have not mentioned because they are the driver conductor, they have no knowledge. This is the ground.
That will be tested in the trial. How can I know? Huh? Is there any stay? No. And they filed, they have been requesting for adjournment. Only adjournment. Adjournment. Huh?
5-10 8 जून 29-10 8 जून.
I'll dispose it up.
चार्ज के लिए of the real loss.
Hmm?
Disposal with liberty to the time of framing charge.
That's better idea. The petitioners in the present case have issued the order dated 27/1/2024, passed by learned SCJM Bhavani Patna, in CT case number 958 of 2023, whereby the court below has taken cognizance of offences punishable under section 379/34 IPC. The petitioners in the present petition have they are contended that they are the driver and the helper,
Conductor and bus.
conductor
Conductor and driver.
conductor and the driver of the bus in which the subject materials were being taken. So therefore, they had no knowledge. And apart from that, they have raised many other issues in the present petition to challenge the cognizance order. At this stage, the matter has been adjourned for as many as 1, 2, 3, 4 times on the request of the petitioner. None appears for the petitioner even today. I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to raise all the points we can put below in the appropriate stage. With this liberty, the petitioner will dispose of. Yes.
61.
Lordship,
Item number 58, I was busy in the
yes.
list.
58, what did I do? Urgent. You want to? Are you?
Non appears, if it is
No,
there,
no.
then.
Appears, Mr. Moon appears. Huh? Mr. Moon,
Sorry, my
on request, करके urgent करो. ठीक.
sorry, my lord, I don't want mention, my lord.
Mention tomorrow. Yes, next.
61.
61.
Compromise.
Compromise, huh? What are the offences?
376, my lord.
Or the one which is mentioned. Will she check if there is any legal impediment? I will not do it.
Affidavit only, my lord.
You just at 12 o'clock you tell me.
Well.
If there is any problem, then we will not do it. Yes.
62. Compromise.
62.
Compromising.
Compromise.
Okay. 65.
My lord, one Passover, my lord. Mr. Dhalok is coming. One Passover.
Passover today may not be possible. Okay, we will pass off. Yes.
66. Mr. All the things were asking for argument. 67.
Yes.
57 NI, yes, my lord.
NI8.
My lord.
One appears in the interest of justice. Yes.
68.
P19 petition has been my lord, against the 319 petition, he has come, my lord. P19 petition, he has added 2 persons.
He has been summoned.
My lord. And we do, in the affair, their name is there.
Name was there. Charge sheet he was dropped. Thereafter, in the evidence, evidence might have come. Okay, it's all right. In the simply adjourn for it because there is no entry model.
Well.
We'll see. Yes.
69.
Yes, 68. You came. Yes. Yes. Tell me.
68.
319. Summon. Yes.
Yeah. And the name of the petition was there in the
FIR.
during investigation, my lord, charge sheet was submitted. The petition was not named in the charge sheet, my lord. And the charge sheet, it was clearly mentioned that since no independent witness, there are independent witnesses at the spot, my lord. Since no independent witnesses,
Please take the. I'll take it up immediately. Not able to speak.
can
Wait.
you pass it over? I'll.
No, you sit down. I'll take. You relax. Relax. Yes.
69.
69 your lordship is a case arising out of a complaint case 420 468 for offense your lordship for seeking for passing your lordship. Notice may be issued to the OP2 your lordship.
Passing.
Yes, your lordship. Offense 420 468 406 120B 506 your lordship.
On what ground?
The ground says that here is the case. The present accused petitioner has taken the money towards the sale one of the flats. But handing over the possession, we are not ready to for executing the sale deed in front of the
Okay, I'll issue notice, huh? Issue notice. Issue notice to the opposite party. Okay. Okay.
70. May I please, Your Lordship? My Lordship, the present petitioner has filed this application to challenging the order of cognizance dated 18/5/2023, my Lordship, that is Annex 5, my Lordship.
Yes.
Yes, my Lordship. I'm
Annexure
filing
5.
this. I'm filing this application with 4 grounds, my Lordship. That first ground is the case is not maintainable because the present check was still stolen one, and the second was that, my Lordship, there is no liability established as per the complainant case that he given the loan, my Lordship. That the present petitioner has in the director of a company that Mata Gayatri Logistic Company, wherein the complainant invested 10 lakhs rupees, and the complainant taking more than 70 lakhs from the company, which I'm annexed as annexure. Annexure 3, page number 23.
What was the check amount?
My Lordship,
What is the check amount?
25 lakhs. That, my Lordship, that check that
Is stolen according to
stolen check, my Lordship, and the GD report is filed, my Lordship, by the annexure 4, my Lordship. And my Lordship, that the check,
all are disputed question of facts.
my Lordship.
That's
No, my Lordship, as per my case, my Lordship, I have sufficient ground, my Lordship.
sufficient ground to defend yourself and get it acquitted. Get yourself.
But, my Lordship, there is
acquitted.
no alternative remedy to drop the proceedings. That's why I'm filing this application.
That's right, but if there are disputed question of fact, I can't go into it. Suppose there are direct straight away there is legal issue,
That only
maintainability or that kind of thing, then I can go into it.
yes, madam. The liability is not maintainable. I have proved it, my Lordship, that
That's what I'm saying.
I have
Prove
proved
it. That the sentence the order which you have said, prove it.
Yes.
That's what I'm saying. You won't prove it.
Yes,
Nobody can stop you.
my Lordship.
So
That
you
my
have to prove it.
My Lordship,
That
kindly,
can, that can only be done in the.
my Lordship, that I am a respected person. To going the court and face the trial, it is also
For that also you have remedy 205 and all.
no 205. That by after framing of charge, I am definitely go to the court.
25 lakhs you go pay and finish it up.
That
if
liability is
you
not maintainable. That is the ground. my Lordship.
Where come? How will I get that?
Yes, my
I
Lordship.
have, see, at this stage, I have to
Yes,
only
my
get the
Lordship.
complaint.
Kindly,
Case is made out, case is made out.
yes, but that cognizance, my Lordship, I'm challenging the cognizance, that cognizance the taken that not following the proper law, that without condone the delay, that magistrate, London magistrate taking the
Oh,
cognizance.
those things you tell me. Those things you tell me so that you have a.
That is my
Otherwise,
last ground, my Lordship.
otherwise on merit I can't go in.
My Lordship, without condoning the delay,
What,
that the London-
where is that? How much delay?
that, my Lordship,
Hmm.
kindly have a glance to page number 15.
15:15.
15,
Okay.
15 to, my Lordship, that page number 18, that part exile, the paragraph exile, my Lordship.
Yes.
That, my Lordship, the demand notice which was served to the accused number 1, return unserved, my Lord, have it, my Lordship, by postal authority
Refuse.
with endorsement refuse, 25/3/2023. And the advocate of the complaint received unserved demand notice on 28/3/2023. That is the first party. That is the company. And the accused 2 and 3 received the demand notice 21/3/2023. But, my Lordship, kindly have a glance. The complaint petition is filed 25/4/2023. The complaint petition is filed 25/4/2023. And as per the 142 of NIR, that is clearly stated that 30 in between within 30 days when the cause of action arises. The cause of action arises as per the complaint petition 4/3/2023, my Lords.
4/3?
2023. It is mentioned in paragraph 1X,
No.
IX.
No. 21/3/2023.
My Lordship.
From there, the limitation recounts.
Yes, my Lordship. That is
And
30 days.
where is your reply to the statutory notice? You refuse.
My Lordship.
You refuse. You have a difficult case, sir. Very difficult.
My lordship, that after
I can only
My
help,
lordship,
I can
first
only
taking-
help you.
My lordship, my
I
lordship.
can only help you by issuing notice.
My lordship, first
Let us
taking
see.
cognizance, then after issue notice.
No.
My lordship,
Yeah.
firstly, my lordship, kindly have a glance the page number.
Hmm.
My last annexure, my lordship.
6, huh?
Yes, my lordship.
Yes.
That is the page number 43.
After taking cognizance, only notice will be issued.
Yes, my lordship, I note that.
Yes.
But my lordship,
Hmm.
that file, the complaint petition was filed 25/4/2023
Hmm.
without the court fee. This is
This
presumed as a immature petition, my lordship. And 17/5/2023,
Hmm.
as per the lady, he pray for exemption of court fee. And the law and trial court exempted it without even not receive the ad valorem court fee. Exempted. Then, my lordship, 18/5/2023 take cognizance.
Section 35.
Without,
Section 35.
my lordship, as per section 142, without
But section 35.
condone the delay. Yes, my lordship, I know that.
Then-
The court fee part is exempted. But my question is that, my lordship, my ground is without condone the delay.
No, delay. I don't think there is delay.
And my lordship,
Cause of action is
This
after
is the- this is-
after the
this is the my lordship
after
last
the
ground.
notice, after the notice is received, and thereafter the cause of action limitation recon from that.
That my lordship, that is my last ground.
I'll simply issue notice. You don't.
My lordship, if my lordship,
You don't have absolutely don't have a case.
Yes.
If you tell, I'll write it.
kindly
I'll write it out.
kindly have a glance.
I'm issuing notice for you.
Yes, my lordship.
Uh,
Try to pass the order, my lord. Kindly have a glance. Page number 40. my lord.
You don't need notice.
Yes, I know.
I issue notice.
My lord, kindly
We'll
have
see,
a
examine. Let him come.
40, my lordship. Kindly have it. Page
Why do you want?
That is the GD report wherein the complaint.
I'm issuing notice for you.
Yes, my lordship. But
Let
the proceeding is
let it be. 138 matter can't be stayed because the statutory bar. Yes, next. You don't have a case.
My
Till
lordship,
I'm trying to do it. January 1st week rakho dekhiyo. Asli.
my lordship, till then my IA is disposal, my lordship.
Next. Huh? 68. Yes.
My lordship.
Yes.
Material.
Obliged, my lordship.
And the petitioner hearing challenging the order passed by the learned magistrate, my lord,
Yes.
wherein on the application of the prosecution for addition of the particular of these petitioners, my lord, the petitioners have been added as accused, my lord. Initially, when the FIR was lodged, all the three accused persons were named in the FIR. One Biswajit Bastia, who is the accused,
Hmm.
and Abhijit Bastia and Jagatjit Bastia, who are the petitioners before your lordship, my lord. During investigation, in
Charge sheet was filed against one of them.
one of them, Biswajit Bastia, my lord.
And evidence has now come against you both, and 319 is
My
resolved.
lord, my lord.
Let us see the evidence
My
straight away. Let us come to the evidence.
Evidence, my lord,
29.
is 29.
Whether
My lord.
anybody has said anything.
Witness number 1, 2, 3, 4.
Hmm.
They are all family members, and they have deposed that these two petitioners were also there at the spot, my lord. That deposition witness number 2. He's the informant. He's the injured, my lord.
Come to page 29, para 2.
My lord. Occurrence took place on 10/12/2023 at about 11:30 a.m. on the public road in front of my house. A marriage function was organized in the family of Hon'Ble and I attended that marriage. At that time, accused Biswajit Bastia, Abhijit
At
Bastia,
that time, accused Biswajit Bastia
Abhijit
and
Bastia,
Abhijit Bastia, you and
Jagatjit Bastia.
another
My-
petitioner.
my-
Both the petitioner name is taken.
my lord.
We are passing through the spot on the motorcycle.
My-
My son so and so was standing near the road, and they stopped. They stopped means all of you
My-
stopped near my son and started so and so. And my son objected to Biswajit inflicting fist blow so and so. And the two other accused persons also assaulted him.
My-
As a result of which my son fell down and so on.
My lord, this was also the allegation in the FIR, my lord.
But that's right. But evidence has come now.
My lord, allow me, my lord.
Hmm.
My lord, during investigation, they have specifically stated there was a marriage function, and also in the deposition, they have stated that there were 25 to 40 people other, my lord. The reason the police did not submit charge sheet against particular to these two persons because none of the independent witnesses stated that these two particular persons,
Page 31, PW2.
PW2, the injured, my lord,
Same.
the injured, my lord. My lord,
Page 34,
my lord,
PW3.
1, 2, 3, 4, they're all related. One is the person.
How will you ignore these evidences?
My lord, come to page.
I'll ignore this evidence
No, my lord.
on the basis of the charge sheet.
No, I'm not asking you. I'm not saying that the evidence may be ignored, my lord. My lord, may come to page number 44.
44.
One of the eyewitnesses was there, my lord.
Yes. 44, yes.
44. My lord, he has not stated anything. Now the 161 statement of the particular eyewitness. 161 statement of the particular eyewitness, my lord, that is at
Page 14.
page 14.
44, I'm there. He has been turned hostile.
No, my lord, Rajkishore Malik, he has not turned hostile, my lord. He has not supported in the during investigation itself, my lord. Page number 53, my lord.
Okay.
So and so date ରିଖ ରବିବାର ସମୟ ପ୍ରାର୍ଥୀରେ 11:30 ହେବ ଆମ ଗ୍ରାମର ଅନିଲ ମଲ୍ଲିକ ବାହାଘର ହେଉଥିବ
53,
my lord
53.
ଆମ ଗ୍ରାମର ସୁଶାନ୍ତ ମଲ୍ଲିକ
You are reading 161 statement.
my lord the degree of proof that is the degree of evidence that is recorded at the state of 319 that is to when
319 is invoked when
initial
evidence comes in the
my lord
depositions.
my lord
Okay.
my lord.
Why are you reading 161 statement?
But what is the quality of evidence?
And now you are summoned. The same witness, you have a right to cross-examine. You confront him with this.
My lord, the quality of evidence, my lord, merely stating it in the during
Quality is not more important. See, 3 witnesses have taken your name.
my lord,
Now you have been summoned
my lord,
because 3 witnesses have taken your
my
name. Then your option is you have to go appear and cross-examine those 3 witnesses.
but that
Demolish them.
but that
Then you are out.
my lord,
That's the rule.
that will be me participating in the trial. But whether this order passed under 319 is sustainable in the eye of law, well, that is the question, my lord.
Sustainable because 3 witnesses have taken.
My lord,
What is the principle of 319?
319 says that.
319 says that if any evidence comes, the court can summon.
My lord. No,
3 witnesses have taken.
319 based a discretion on the magistrate, my lord.
He has exercised the discretion, rightly so.
But the discretion cannot be in bereft of the law, my lord. The
What
law,
is the law? You tell me.
my lord, the law in this point that the evidence that the degree of satisfaction that is required is one that is more than that is required at the stage of framing of charge, but less than that is required for conviction,
Right.
my lord. At the stage of framing of charge, also the magistrate has the opportunity to go through the evidence without going into the veracity of that.
What is your argument is 3 witnesses, those who have deposed against you,
My lord.
are related witnesses. Okay?
My
They are relatives.
My
So they are interested witness.
My lord.
And the one independent eyewitness has not supported the prosecution.
No,
That's why
there are other independent
and
witnesses
you
also.
tell me then all on other independent witnesses
Not-
are not
not
supported. However, 3 witnesses, those who have taken your name,
My
they are related.
My lord.
So therefore, they are interested witness.
My-
You show me any judgment that at this stage, merely because they are interested,
My lord.
I can ignore those evidence.
I'll give the judgment, my lord.
Show me now. This is your case, and the entire case is this.
My lord, in a Ross, I could not bring those judgments. Well, I have the judgments where the
You won't get any judgment.
I have the judgment. I have gone through the judgment. In a Ross, I could not. Well, I could not. I have the judgments, my lord.
Friday.
Well,
Come with judgment. Don't take
Fine.
me here and there.
No.
Simply say 3 witnesses, those who have deposed against you, are interested witnesses,
Fine.
and all other independent witnesses not supported. So the magistrate has wrongly exercised the discretion under 319 and summoned me.
Fine.
Because the 3 interested witnesses evidence has to be ignored at this stage. Bring some judgment, I'll give in.
My lord.
Okay.
Along with
Friday.
the principles, my lord.
Right. Okay. Don't take me here and there.
No,
Okay. Yes.
May I beg apologize, my lordship, interrupt in the midway. That's item 69. Lordship,
It has already been
yes,
done.
Not, I agree to lordship. Non-appearance.
Notice I have
I
issued
lordship
notice.
non-
Yes, next.
Non-appearance is a setting.
Non-appearance. Appearance. Huh?
Malas. Grateful.
I'll not put non-appearance.
Lordship, I will grateful.
Yes.
Grateful. Malas.
71. Why should your client misunderstood it?
Certainly, Malas. I grateful.
That I'll not do. Yes.
Malas.
I have already issued notice before you argue. Yes.
Malas.
May it please your worship.
Yes.
On item number 71,
Yes.
the impugned order is at Annexure 5, page number 41, my lord.
5.
My lord, the discharge application of the petitioner has been rejected by the learned special judge vigilance, my lord.
Hmm.
And the allegation against the
And henceforth, whenever you come with full judgment. Don't say that
I
after
will.
arguing when the court is not agreeing,
ma'am.
I have some judgment.
My-
Why can't you bring the judgment? You can come.
I always come with the
Yes.
judgment. Even I have
It's
cited
anyway,
the
but
petition.
henceforth you do that. Yes.
My lord, the impugned order is at Annexure 5.
Yes.
The learned special court vigilance,
Hmm.
Bhubaneswar, has rejected my application for discharge, my lord.
Hmm.
And the allegation against the present petitioner, the present petitioner was working as a PT in a Godarodonga college, Puri, my lord.
Yes.
BJP college, Godarodonga.
Mhm.
In the year 2007, he wanted to contest the Panchayat elections while working as a PT in the college, my lord.
Hmm.
He sought for permission from the governing body of the college. Governing body accorded permission, my lord. That also I have annexed.
Yes. Yes.
Governing body accorded permission, my lord. in the permission, however, there was a rider that you cannot take salary from both the both the witness, my lord. Accordingly, I have discharged the duty of a PT as well as the discharge of the duty of a sarpanch, my lord. In the year 2011, the honorarium that I received as the sarpanch, I have returned that. That also I have annexed the receipt, my lord. In the year 2013, an inquiry was undertaken that in the year 2009, block grant was accorded to my college. My name, 12 employees of the college were sponsored by the governing body, secretary countersigned by the president of the governing body. Of those 12%, in those 12%, my name was also there. In the year 2013, an inquiry was undertaken into all these proceedings that while discharging my duty as a PT, I could not have discharged my duties as a sarpanch. Therefore, the block grant that was accorded to me, that has been accorded to me for 3 years, that is a misappropriation, my lord. That is
Yes, who is appearing? Sir, how can it be a misappropriation?
It's not a case of misappropriation, but if Lordship permits, my lord, before I place the materials or the
He has only tweaked the rules and taken the money, you recover it.
That's what I
Where is the
suggest.
corruption about it?
What I suggest, my lords,
Yes.
before I bring to Lordship notice regarding the materials or the findings which indicates his complicity, my lord, may I bring Lordship notice the earlier orders by the co-equal bench. While he has approached this on court, not only this on court, he went to Supreme Court also. Let's say have a glance, my lord, annexure, page 39 may be glanced through, my lords.
39?
Page 39 is the operating portion.
39.
The orders passed by this the co-equal bench of this on court, my lords.
Who is, he is Upendra Kumar Dalai. See, you. Okay.
Page 39, my
Why
lords.
have you come here? This matter?
No, this is my lords, petition submitted.
Cognizance order you challenge.
Okay.
I had cognizance order. I went to Supreme Court.
Lordship, all the matters are played with the honorable coordinate bench of this one court. Para 6, considering submission made by the learned counsel, the waiting for the respective parties on careful examination of the materials on record. The input order, this court is not inclined to interfere with the input orders, my lords. And let's turn to next page, page 14, my lords. The tribunal being undeterred by these particular orders, they moved to Supreme Courts, and Supreme Court also turned down the proper pleas, saying that you go and approach the Lord and trial courts by filing a registered application.
That he can apply for discharge.
Discharge, not inclined to interfere in the input orders passed by this on courts. By this is Mahapatra. Let's return to the next, my lord. He preferred that revision of petitions, my lord. I mean, the petition for discharge, my lord. And let's return to page 43, my lords.
Yes.
Page 43, I'm placing, you'll also need the first 3 lines. The important line starts. The present accused who was working as PT BJP College, who has misappropriated government money to the tune of rupees 1,48,440 by simultaneously holding the post of Sarpanch and PT of the college from 10/3/2007 to 10/3/2012 by manipulating the college attendance and acquaintance register in connivance with the accused Samant Kumar Roy, ex-secretary of BJP College. So and so on perusal of the records, it is seen that the present accused joined as PT on the first post of BJP College, so and so on 28 August 98, as for the appointment letter, so and so issued by C. Roy, the governing body. With reference to the letter dated to 25/2/2009, the Director of Higher Education named the present accused was sponsored by the accused for sanction of 40% block grants, and that during the periods from 21/2009, this is important, to 29 February 2012, the present accused has received block grants of 1,48,440 towards his salary as paid to the college. The case record further reveals that the present accused, while continuing as paid to the college, he was also elected as Sarpanch of so and so and receives 4,800 towards honorarium and in 1,980 towards shooting fees of so and so. At the same time, the present accused had also received block grant rupees 1,40,000 towards the salary of PT College. More, the president had or not informed the Department of Higher Education that he was elected Sarpanch. That's the inaction inadvertent. I mean, not inadvertently, but
what are the charges then?
That he has not informed in all this, Lord. If Lordship permits the charge sheet, my lords, the relevant page is 34, my lords, from the charge sheet, my lords.
Where is 13.2 and 13.1D? I don't understand. 420, 420, 468, 471 and made out.
I got your lordship points.
Very 13-1.
They both work in tandem with the secretary and all this, the particular person. And lordship content, what are the if lordship pays 34, the charge sheet, I'm placing the relevant pages only, the third paragraphs. It starts from the investigation as revealed for that's a provision under section Education Act and the granting law 2008 is mandatory requirement. One should have continuous service to get financial assistance with lordship. In the instances, say, so-and-so secretary they had not taken proper care to intimate the correct information about the employees to the government while recommending sanctions. So he worked with other person lots to take out
manipulation and all this thing. 468, 471. I can understand. Where is
your lordship?
Where is 13-1, 13-2?
Your lordship expect other materials which indicates about the factor of manipulation. I mean, sorry, the misappropriation. Your lordship, this is coming for the first time. Lordship, give me 2 days time. I'll come back to lordship. If there is any materials regarding his manipulation or what are the allegations that
corruption connotation is altogether different.
13. I agree, lordship. I agree with lordship. Lordship.
He is entitled for 2 salaries. Okay. And he was supposed not to take salary of one this thing, and he could have taken 1 salary. He has tweeted the rules, whatever, and manipulated document. Had taken money from both the sources.
Withheld the information.
Both the sources. Where is the corruption about it?
Withheld the information.
Then 420, 468, you are doing whatever you do, no problem. Where is 13 and 13-1 too?
So for that matter, let me go through the other documents. Lordship will take the Friday. I'll come back to lordship.
I'll issue notice. Issue notice and move application. 13
I got the
charge so far as 13-2 and 13.
Lordship is indicating
is not made out. Other charges are made out.
My lord, regarding other charges also.
No. Other charges.
There is no forced document, my lord. They're saying that
That will be tested somewhere else.
They request
Whether you forge or not.
by additional evidence. Correct, lordship. Correct.
You have manipulated the document, and you have what had happened is when the school started getting grants, you saw that the money is available. I should take it. By that time, you had already taken the money from the surplus.
Your lordship correctly.
That is the problem.
Your lordship correctly lifted the file.
That is the real problem.
Yeah, I agree.
He had taken the salary from that surplus thing. He was not taking. Once the aid came, he thought that better money I am getting. This also I'll take.
Aid came in 2009, my lord. Aid came in 2009.
You took it, and 420, 468, 471, 120B is made out.
I have taken permission.
13-2, 13-1D is not made out.
Now the thing is reverse around about the 13. 13 prophecy.
13 is made out or not?
I had taken prior permission. I have not suppressed anything, my lord.
You should have intimated.
That is the reason I'm saying 13 is not made out.
Well, it is a case where discipline.
But if you have manipulated documents,
I have not manipulated documents.
That will be tested in the.
That's a difference. That is to be tested.
Bring about
by
manipulation. There has to be a forced document. There is section 468, my lord. 468. There has to be.
That will be tested there. That's the allegation. What?
The document seized in the charge sheet also does not mention there was a forced document.
We'll see. Examine it. Okay.
Whether the document was forced or not.
Next.
My lord, for
you move application. Yes.
There is an
I have said that you move application for it. We'll see. Yes.
72. My lord, kindly pass over.
Pass over today, sir. Belgium.
Belgium, but what happened? 2008 se release ହେଇଥିଲେ April ହେଲା 2024 2024 ରେ
Bail के भेज दिला?
2008 5/3/2008
Bail. And NW?
It's 8/4/2024.
That means till 24 he was appearing. That means he has been participating. Therefore, NW was not issued. Okay. 500. Okay. 500. Yes.
NBW dated my lord 21/2/2024 bail on 25/6/2021
NBW is on
21/2/2024
okay, 500. How many? Yes, 500. Yes.
74.
Yes.
74 is the case 304, your lordship. Here is the deceased. Wife is the informant. Husband of the informant is the deceased, your lordship. Garam pani party mula jala garam madu pi ki hamna garam pani tela garam pani padi gale. Succumb to burn injury, thereafter death.
Death.
Death, your lordship. But what happened, incident happened 1/3/2024. On that day, he was admitted in the hospital. 5/3/2024 is passed away, but FIR has been lodged on 18/3/2024. your lordship.
Is it an is it an accident or intentional?
No intention, there is no intention.
Then it is an accident, then he is entitled to bail.
Incidentally, partner lagte garam pani ki manso kariya garam pani ka bill korte jo mutton cover kariya kariya pai. Isme podi garam pani pani
Next week रख दिया ना PS next week रख दिया. Yes.
75 मतलब पास हो
75, 76, they both are the connected matters, lordship, but both are connected matters, lordship. 76 are kindly taken up, your lordship, it suffice with the 75 is of fact to be kindly
Yes.
carried.
76.
Maybe.
76 and
This is the second down journey. And Malad is added to come after examination of the informant and the victim Malad. Now they have been examined as PW3 and 5. Malad will turn to the evidence of PW3. Page Malad.
16.
Yes, 16.
Custody?
I guess custody both. He's in custody. Malad 5/2/2024. And the offences are all a tribal magistrate, 7 except the POSCO Malad. And the 354 and 354A.
No, earlier you came and what was the order earlier?
That is earlier order in BLAPL number 4717.
Blind girl.
Aye. Regarding 354, no.
See, show me the examination.
Madam, page 16, Madam. 16, Madam.
16.
Aye. Para 2, Madam Messi. 1 is not necessary. 2, Madam Messi.
Girl?
Para page 16, para 2, Madam.
Yes.
Mid part of the para, Madam.
10 months back.
Aye. That is starts from that, Madam. 10 months back, such and such. At that time, both the accused persons controlled me and closing my mouth by the such and such. The napkin took me on the motorcycle on the cyclone towards the cyclone home, where both the accused persons pressed my debts and slapped me by ear and fled away from the spot. Then I returned to home and narrated the story. And so far the informant, Father Malad Messi, page 20, that is page 21, Malad, 21. He has not started anything, Malad Messi.
21.
Aye. Father, who is the informant, Malad? Same para 2, Malad. I've got it, Malad. Page 21, para 2, Malad.
No. 10 months back,
Aye.
one of my daughters would be there.
While from the nearby shop at the time, the accused persons came, closed her mouth by the odoni and took her with that in a motorcycle. Cyclone stood. Then the accused persons slapped on her and pressed her neck and body on that on the next day. I such and such.
There is no penetration of it.
That's right, but the allegation
I know, I have. She is a blind girl, that is the part.
keeping in mind
And she is already, they are already there for.
8, 9. And no previous case.
So as per the implementation order, out of 5 witnesses, already 3 had already been examined. No, 5 has been already examined, you know.
What is the age of this girl? Let us see.
Girl is Malad Messi. She is Malad 3. Age has not. It's
Very difficult. See, trial courts are not recording anything.
Civil court in view of the charges, Apex Court. Victim name not to be disclosed.
Victim name you not right. At least something.
Yes.
And
Otherwise,
see the other evidence also.
in a recent case, it was confused. Victim and friend of victim, both name has not been reflected. Their signature has not been reflected, Malandi. Then how the concerned counsel or anybody, the appellate court will know about the identity of the person? Yes, of course. Name has to be excluded. The
Name you may
yes,
exclude.
the
Age
father's
at least you should write.
father's name.
This is minimum.
The address, it can be.
The FIR has been 16 has been wrote, and case the head of my London senior street. Is 16 7 16 minor 16.
This boy is 22 years. There is no penetrative for this thing. They are already there for about a February to Royal Lady.
16 ವರ್ಷ. So victim is 16 ವರ್ಷ.
Right on. Petitioner is an accused. What about 75?
75 is the same.
Another accused. Another
Three
accused.
local.
Petitioner is the 76 local. The petitioner is one of the accused in FIR number 4. Allegation against the petitioner. Earlier, the petitioner had approached the court by filing BLAPL number 4717 of 2024. This court had disposed of the bail application on 12/9/2024, inter alia stating as under para 3, 4, and 5. 3, 4, and 5. The evidence of the victim girl has been recorded as PW3 on date we कुछ नहीं दिया। मतलब what kind of where is the date?
Certificate copy I brought.
Certificate copy you must be having.
Yes, there is certificate copy. I have the certificate copy.
Date तो कहीं होगा।
किसी नहीं आएगा।
That's right, but you don't write the, see in the front there is a column. You are supposed to write the dates.
Yes, that top of the not mentioned. Madam, we pass some judicial order to that because in such a case, let them ignore the name of the victim.
But other things has to be filled up.
And they are saying identity. Identity means only name, my lord.
Very, very difficult.
Unless until they give
Date has to be written.
Date, at least the daughter's name.
And the second, see, taken in solemn form on such and such day. Date तो रखोगे?
सब उड़े हुए थे.
Maybe on the same day might have been. For 2 जब ही चला.
Yes, yes.
30th October ही थी. 30th October ही है. 30th October. 30th October लिख दिया. कौन लिख लो? 30th October 2024. The victim girl has inter alia stated as under para 2. The victim's father, who is the informant in the present case, has also been recorded as PW, who is a PW5. He in his testimony has stated as under para 2. The testimony of the aforementioned 2 witnesses are corroborating with the testimony of other witnesses. So in nutshell, therefore in the nutshell, the allegation is the petitioners have the petitioner he has misbehaved with the girl. There is no allegation of penetrative sexual act committed by the present petitioner. The petitioner has been in custody since 5/2/2022. Regard being had to the age of the petitioner being 22, and period of custody from 5/2/2024, and later of allegation, and then inclined to enlarge the petitioner on date.
The mother of the victim.
अच्छा, mother of the victim. पहले भी चेक कर दो, सेम तारीख कर दो. 75, 76 allowed. And condition कर दो he will be not in touch with the victim girl during the period of bail, and he shall appear before the court diligently without fail on every date of hearing.
77 is 376. This goes going there. Notice to be issued.
Notice issue, notice 77. Yes.
78, 302 and 94. 27, 29 arms act. CD is not available with me.
Call for CD. Okay. Next. 79.
Offense, 373, 34 IPs.
Yes.
This petitioner is Ghasiram Harijan. Same putting another co-accused Tikelal Duria was granted bail by the Hon'Ble court. Another allegation by labor
Labor should be contractual.
only mile.
370. What?
76D is not.
Ghasiram
Harijan.
all allegation against him. All allegation against him. Where is the co-accused bail?
Mile. This is Tikelal Duria and Ghasiram Harijan.
No. Tikalal Buria. There is no allegation against Tikaram Buria. All allegations are against this man.
No, my lord. 164 is there, my lord. No, nothing.
Read it. 164.
ଗତ 4 ମାସ ତଳେ ଆମ ଗାଁ ଘାସିରାମ ହରିଜନ ଆମକୁ କାମ କରି ନେବା ନା
No, but I need not read. Gasiram. Everything, I remember it. I remember. Gasiram has done everything.
ଆଜ୍ଞା ଖାଲି 373 ହବ
Wait, January.
ଆଜ୍ଞା ଠିକ
January.
ଓଲେ
January. Wait this summer.
ଆଜ୍ଞା
Yes. 80. Tikaram has not done anything. Tikaram's brother-in-law has received them in the. That is the allegation.
ଟ୍ରେନରେ ବସେଇଲା
But Gasiram is the guy who has started everything.
ଘାସରା ମାଣି ବୋଲରରେ ବସେଇଲା
He took these people and made them to sit in the Bolero. That Bolero went to Visakhapatnam. On the whole story I remember. Yes.
ଜାନୁଆରୀ
Wait January. Till January. We'll see. 80. Yes. Pass over. May not reach. Okay. Pass over. 81.
His father-in-law expired. 302 direct evidence is there, but his father-in-law was expired. Your worship directed on Saturday.
Acha, interim bill.
His father-in-law expired.
Okay. The petitioner has moved the present. What is the application, sir?
IA number, my lord.
IA number?
1585.
85. Petitioner has moved the 1585 moved an application for grant of interim bail on the ground that his father-in-law has expired and he needs to participate in the rituals. The notice was issued to the state and the instruction was sought from the concerned IIC. The IIC Banki PS has submitted a report.
PG Hospital, Kotak, for
Treatment is expired.
During treatment is expired.
Furnish the following inputs. Following this. The paragraph regarding to the aforementioned facts and the instruction received from the IIC Banki, the petitioner is granted how much?
15 days.
20 days for 20 days. No, offense is 302.
302 omnibus alias.
Okay, whatever.
18%.
20 days interim bail, and with the direction that the petitioner shall appear, surrender immediately after the expiry of interim bail. The petitioner shall be released by the court below on the condition of being fit and proper. Insofar as the main bail plea is concerned, let counsel for the petitioner seeks to withdraw the same to renew the bail plea before the trial court immediately after his surrender on expiry of the interim.
With further condition, he should not come in contact with the.
With conditions will be enforced.
One prayer man, course of the copy possible.
Yes. Yes. 82. Yes. Yes. 82.
80 madam.
Password.
Leave track.
Huh?
Leave track ला उठे देरी है गलस.
But ठीक है, ये पास हो रही थी. Yes. 82. Yes, madam.
The petitioner herein is in custody since 23/6/2023.
23/6/2023.
In previous occasion, the lordship bail application number 12537.
Yes,
There is
your
fine.
lordship permitted us to move the court again.
In that CD was available. Now the CD has been returned to the. I will call this.
Next week. Okay. Next week. CD. Yes. 83.
83, the restoration application filed by the.
Restoration. What happened?
The delay, the 44 days delay.
Delay 44.
Yes, notice.
Delay condoned for the reasons stated in the application. what is this? OJC? What is that? Huh?
Challenging the order of the toss.
Who is anybody is appearing?
No.
Then those who urgent court. Non-APS urgent. Yes. Huh? Liquidates not filed, urgent court. Yes.
84.
84
No, no, see,
restoration.
1 minute.
Here,
83 na?
1045 days
For
delay.
issuance of press notice on so apparent case address not filed. See, they go there. Non-APS for the petitioner. 83, yeah? 83. Non-APS for the petitioner. Even the requisites to serve reference notices on OP number 25679 has not been filed by the petitioner. In the interest of justice, the matter is adjourned to such and such day, and the petitioner is directed to file requisites for issuance of press notices to opposite parties, unserved opposite parties within a week. Within a week, if the requisites are not filed within a week, the CRLMA, CMAPL shall stand dismissed for non-prosecution. Without referring to the court, generally. So don't file in the. I don't know what had happened.
58 onwards, yes.
58 onwards we have taken, yes. 84.
84.
84, your
Yes.
lordship, flag I, flag J and flag K for the substitution, limitation and setting aside abatement of the respondent number 10, dependent number 10.
Yes.
I'm for opposite party number 2 to 7, Milots. Plus the IS that have been filed and a memo has been filed. May kindly the copy may be served because the contents are not known.
Which I you are talking about?
Because there are 3 IS on board today, Milots. 138, 139 and 140 of 2024.
I'll serve the copy, your lordship.
Now, what is this? What is this case about? Let us understand.
This is arising out of a regular second appeal whereas Milots, the matter was dismissed for default for non-appearance and they filed an appeal to restore the RSA Milots. Whereas in the meanwhile, some parties have died and they are seeking substitution in the CM appeal so that it can be restored.
Are you opposing it?
Milots, the point being is that I do not have that IS to know the contents. I need to know the contents of the IS, Milots.
Supply the IA, let us see, put it in January. Supply the let counsel for the petitioner undertakes to supply the copies of IA, file IA to the counsel for opposite party, lease the matter. Yes, yes.
85.
May I please, your lords? It is review petition, your lords.
Yes.
Against the order of single bench, I have filed a writ application by obtaining some documents. After hearing the matter, the Honorable Court directed to file a review petition.
Review of which order?
Review.
The impugned order.
Impugned order is
page
annexed one.
8.
Yes. They have rejected on the ground that the petitioner has been participated in the selection and he could not successful in the, so the case is dead.
Where is that order? The order is
Page 10, your lordship can see.
19, huh?
Page 10, your lordship.
10.
Yes.
The operating.
Operating part. Last part. As the last part, as the petitioner participated in the selection process and could not be successful, cannot challenge the same at this time. Okay.
You not participated.
I have already participated in all events now. Kindly see, your lordship. Thereafter, I filed a challenger writ application. Writ application, some document. Kindly see, your lordship. Running page 12, your lordship. Running page 12. Last selection is 32. And running page 32, your lordship. 12, your lordship. That is last selection, SC is 32.
Yes.
Petitioner.
No, you have been unsuited on the ground that you have participated in the selection process and after having failed in the selection process, you have challenged. So you have been debarred.
Debarred for
that's the order. What is the apparent error in it?
Ignore that order, I filed a writ application. In the meantime, writ appeal. Writ appeal by obtaining some document, RTI document. Though the petition is except viable, he has obtained 34 marks and including viable, the last selection has gone on 32. 32.
What happened to the appeal order? Let us see.
Your Lordship, kindly see
Appeal order.
19, page 19, Your Lordship. The Honorable Counsel for the appellant seek leave to do the appeal with leave to file a review petition before the Honorable single judge on basis of the document now obtained by the appellant
Okay.
under
Now, what are the document? The RTA documents?
under RTA, kindly see, Your Lordship. That is RTA document page 11, Your Lordship.
Right on.
It's, as regards
The
supply.
present review petition is filed against the order dated order dated 22/2/2022 passed by the learned single judge of this court in WPC bracket OAC number 2908 of 2016 on the on various grounds. Next paragraph. Against the said same order, the petitioner had approached the division bench of this court by filing WA number 431 of 2022. The division bench, by its order dated 30th November 2022, have granted liberty to the petitioner to file the review petition. The text of the order is reproduced. Page 19. Text of the order. Okay. Pursuant to the liberty granted to the petitioner by the division bench, the present revision petition has been filed. Issue notice to opposite parties, returnable on such and such day. Bas.
Both are same, Your Lordship. Both are same.
Yes. Both are same means?
Yes.
Acha, both. Okay. Both is provided. Yes.
86.
My Lord, petitioner prays for modification of the order dated 9/9/2009, my Lord.
9/9?
2009.
Where is that order, sir?
It's a page 10, my Lord.
Where is that order?
Page 10.
Huh?
321524, page 10.
Page 10.
Yes, ma'am.
Yes.
The petitioner was charged under section 13(2) and 13(1)(e) of the Prevention of Corruption Act. NBW was issued, so he had approached the Hon'Ble Court. While granting bail, my Lord was pleased to.
Which condition?
My Lord?
Which condition you have agreed?
The condition number 3.
Huh?
Condition number the 3, my Lord, 1, my Lord. Condition number 1, my Lord.
Sir,
So
for
10 lakh is your deposit. So in the
Yes, sir.
meantime, although he has retired since long, he is not getting his pensioner benefits due to the pendency of the case. So I pray to relax this condition.
10 lakh rupees.
Yes, sir.
But see, this order was passed in 2009.
But still that is continuing. My Lord. The case is again now it is a PML ko transfer. So that is continuing.
9/9/2009, 10 lakh rupees, you got the bail and all. Now,
Now I have deposited the amount. Now I pray to reduce that amount, my Lord.
already deposited.
Yes, ma'am.
Once you complied, what can I do? What can I do? Once you complied it,
yes, ma'am.
then
The difficulty is that, my Lord, since the case is pending, he is not getting his pensioner benefit.
you move
So-
application if it is pending there. But once you complied it, the bail condition, you have complied.
Yes.
You enjoyed the bail from 2009.
Yes, ma'am.
Today we are in 2024.
Yes.
You want relaxation of that.
No,
That means you want refund of that money.
No, difficulty is that since the case is pending, I am not getting my pensioner benefit. So I want some money for my medical treatment issue. So that can be reduced, my Lord. I can get the benefit.
Who is appearing?
The vigilance department. Then now.
Vigilance. Anybody is there? Vigilance? All of them were there.
Now you can PML. Now PML. The case has been transferred to the court of the PML.
Just check it up. What is the stage of the trial in this case?
So, trial not comments. Only transfer not comments.
We'll call them, we'll see. You want full 10 lakhs full refund or what?
Or something, at least 2 lakhs can be back rest.
Mr. Das, it's a very peculiar case, but I think he deserves a little merit. What had happened is in 9/9/2009, bail was granted to him with the condition that he will deposit 10 lakh rupees. He has deposited, he has been enjoying the bail, no problem. But today he says that because of the pendency of this case, he's not getting the pension and all. He wants back that 10 lakh rupees. Condition. See, why have you pushed the condition? The condition is only to ensure that he should participate in the trial. He has been participating in the trial from 2009 to 2024. There is no doubt about it. Then why should he be imposed this onerous condition? The onerous condition has to be removed. Two prejudices causing to him. First of all, you are delaying the trial. His money is stuck. He's not getting pension.
Attributed to prosecution for the delay.
Whatever, but he is suffering the trial. He is participating. If you say that he is not participating, then the condition, okay, no problem. He has been participating from 2009. This is the onerous condition. And this condition was only imposed to ensure that his presence in the trial court,
Correct.
which he is doing it. Why should you retain that money?
It is coming the first time.
I'll just issue notice, check it up.
Huh.
I think I should.
I'll come back to
we
the
should
post
give.
positive instruction.
And some other condition, if you want to impose, tell me. I'll impose those conditions by replacing this.
Correct.
Let him get the money at
The
least.
condition will substitute.
Because the problem is he because of this case he is not getting pension. His money he can utilize for his it. And I don't know how many years you will take to conclude the trial. Why his money is stuck? Just
Lordship,
take
issue
it
the
up.
notice.
I'll issue notice. Just check it.
I will come back to your Lordship.
Come with the right solution. Okay.
I assure this.
Yes, issue notice. I'll just check it. Okay.
Get a copy.
January. Why January? December this side kar do na. He needs money and to give it. Yes.
87. 87 a compromise method. Pass over. As you look.
Pass over.
Yes.
Are they coming today?
Yes. Sir.
But before lunch.
Before
12 o'clock.
Yes.
Yes.
Before.
Yes.
88.
Item 88, your Lordship, I may be permitted to withdraw.
Thank you. Withdraw.
89. Item 89 Lordship, raised from pass over.
Pass over. I'll put it on Friday, sir.
Well,
Friday, because today it may not be possible. Friday,
Well,
yeah? Friday. Yes.
90, I prefer a passover, madam.
Pass over today may be difficult, but I'll do it. Okay. Let us.
Okay.
I may take out. Yes.
91.
91. Notice service. Opposite.
Item delivered section.
Despite the service of notice on opposite party number 2, non-appears in the interest of justice, adjourned. Yes.
92.
Notice section.
92. Notice service. 92. The same order for the despite service of notice, non-appears, increment. Yes.
93.
Item 93, kindly be permit me to withdraw to file a better application.
To file a better.
Yes, sir.
94.
May I please, your Lordship?
Yes, sir.
My Lord, this is an application for modification of order 26th November 2024, my Lord.
26 November.
2024, my Lord.
Yes. What? Correct.
Page number is 8, my Lord. IA.
What correction?
Paragraph 5. My Lord, NBW was issued by Nyaya Adhikari Grammya Nyaya Odoga. But inadvertently, it is mentioned as the NBW order dated 18/7/24 passed by the Learned and Additional District and Session.
Correction करूँ हाँ ये 26/11/2024 You have done it. Take it up. Okay.
My Lord,
Correct. Okay.
time may be extended.
Time extended till 25th. Hello.
95 same. Same.
Same. 95 कर दो.
Pardon, your Lordship, in item 89, there is interim order, your Lordship, kindly wait.
Interim order continue. Wherever interim order continue. No problem. Yes.
96.
May I please, Lordship, here actually, well, there are two criminal appeals in which I have filed to IA seeking permission to prepare paper books and for expeditious hearing. As I, my lord, inquired already, TCR is available. I will take it in soft copy.
Yes.
I pray, my lord, it may be listed henceforth under the heading hearing for hearing, so that.
For the work, hearing that. Okay.
Obliged.
Let them prepare the paper book and serve the copy, my lord. I pray before your lordship.
Give a copy to him also.
Soft copy, my lord.
Yes.
Preparation of paper book. And my
Yes,
lord, next item 97. 97, another matter is there. It has not been tagged. CRLA 591.
591.
Yes, 2022.
97, 590.
Obliged.
591-22 along with 591-22. The same advocate, same parties, same.
Okay.
Two cases.
590. Okay. 98.
Obliged.
98. Why is it? Hearing.
Pass it over.
Hearing.
Mr. Simon Das will do it. May pass it over.
Hey, wait, is it for hearing what?
For condonation delay, I think they are at flag.
Nobody's there.
At flag A is there an application for condonation.
Hear it.
Let notice.
Notice.
In the matter of limitation.
Notice. Conveyance notice for the bus. Yes. 99.
By REST postponements.
So 99. 99. What is this?
Sir, 99 is a very peculiar circumstance, sir. The brief has, sir, somewhere it has been misplaced. Sir, if the council would have appeared, I would have requested to supply an spare copy so that I could have reconstituted the case, your lordship.
You know who is the counsel? Mr. Avas Mohanty, he was there appearing. None appeared. Avas Mohanty. I'll just, then what I'll do is I'll pass it over. He may come.
Yes, sir.
Then you ask then.
Lord,
Okay.
Lord.
I'll just. Item 100. Yes, 100.
May I please, Lord?
Yes, sir.
Lord, I am for the petitioners. Here I have challenged the
What happened to mediation?
mediation failed, my lord. Here, my lord, what has happened? One of the nephew has filed the case against the maternal uncle. The mother filed the suit, disputing the sonship of the present petitioner. That is for one's brother. In that suit, a compromise was made. In the compromise, she was given certain land. She got it recorded in her name. Thereafter, she sold the same.
Who are you?
No, I am the brother.
You are the brother.
I am the brother of that plaintiff in the earlier suit, man.
So then the entry order is that. Let continue. We'll hear it. Okay.
TCP matter, where he claims for harassment on the ground that the CRP is filed, while the compromise decree was obtained by fraud. IA was filed. IA, my lord, was filed to set aside that decree on the ground of fraud.
In this matter?
Mello?
He's arguing in this matter?
Yes, yes.
Yes, my lord.
Yes.
My lord, IA was filed on the ground that the compromise decree should be set aside, having been obtained by fraud. He filed petition to reject that IA. That was rejected. It was challenged in CRP before the Honorable Court. Your lordship will see from the criminal miscase petition, the ground is that CRP is pending, stay has been granted. In the meanwhile, the CRP has been dismissed. So far as that CRP is concerned. Now the complaint case, he says that since the dispute was that whether I am son of Loknath or not, and there was a compromise that I am son of Loknath, which has been obtained with fraud. So therefore the criminal case is misconceived. But that is not the only thing. If your lordship will see page 56, he has not only described himself as son of Loknath, even he has changed his name as Hrusikesh instead of Ulas and has sold some properties. So that's a case of fraud. So he cannot say because there is a civil case, there cannot be any criminal liability. So in essence,
hey, Ullas Chandra Samantara, 55. What are you saying, Ullas Chandra?
Again, say Ullas Chandra Samantara.
Ullas Chandra Samantara is the petitioner.
Paragraph C, paragraph C, page 56 of the complaint petition. Paragraph C, page 56 of the complaint petition.
Yes.
So my allegation is, if with your lordship's kind permission, may I just place it? In order to grab the properties of Loknath
Described
Samantrai.
himself as Hrusikesh Samantrai.
Yes. So son of Raghunath Samantrai. My lord, we are saying he is son of Raghunath Samantrai. He is not son of Loknath Samantrai. Now, purportedly, he got a compromise that we accepted that he is son of Loknath
My
Samantrai.
submission
Now,
is
that
can it
compromise,
be decided by the Honorable Court whether I am the son of X, Y, J
my
or
lord,
Z.
no, I'm not saying
For
that.
that you have to take a declaration. Once
may I just-
his mother filed the suit challenging the parentalship of myself, and in that suit it was compromised.
What he says is by this is impersonation.
Impersonation, but that
you have impersonated yourself, saying that I am Hrusikesh Samantrai, Raghunath Samantrai.
that is not the question.
You have taken the properties.
But he is nobody there. In respect of that property, he is nobody. He has no right over that property. He is not claiming that property.
has no
Apart
son
from
called
that, can it
Hrusikesh.
be decided by the criminal court that whether I am Raghunath or I am Lokanath, son of Raghunath Lokanath? And once the issue has already
Hey, whether you are Ullas or Hrusikesh.
I am the Ullas. I am Ullas Samantrai.
But you have
Now,
said
what I humbly beg to submit, whether he has impersonated as Hrusikesh or not,
What has happened, my lord, when he was a child, some property was gifted to him, and it was gifted in his nickname. That is why he.
What is your nickname?
No, nickname that they have given. That is.
How many names you have?
No, Ullas is my original name is Ullas.
You have also said that you are Hrusikesh Samantrai.
No,
that's the allegation in the complaint.
Allegation is the complaint case. So, my lord, that cannot be decided in the complaint case. That is
no. If you have impersonated yourself, you are Ullas. You have said that I am Hrusikesh. On that basis, you have taken some property.
I have not taken the property. That property I have not
That's
taken.
the allegation.
I have that property I have not taken from the informant or the complainant. That property was given to my elder father.
Those things I am not interested. I am only interested whether you have impersonated or not.
No, man.
If it is impersonated, then it has to be tested.
No, I have not impersonated.
How will you deal with this allegation?
That I have taken step.
Para C, just C. Para C of the complaint.
I have given, my lord. In Para C, I have given.
In order to grab the properties of Loknath Samantrai, his Ullas Samantrai.
Yes, sir.
You used to describe himself as the son of Loknath Samantrai, and also this Ullas Samantrai, in order to grab the property of others, change his name.
I have
described himself to Hrusikesh Samantrai, of Raghunath Samantrai. You are changing your father's name, you are changing your name, and
there are one more line thereafter.
No, those things, property dispute and all will be sorted out there in the suit, no problem. But
another suit,
with the cognizance is taken because of this allegation. I have to only see whether the allegation is there or not. Prima material is there or not. And then that's the only thing.
In that respect, my lord, I will file an affidavit with. I have some documents. I'll file by way of affidavit.
File it and satisfy me.
Yes.
Interim order to continue and lease it.
The only thing I am saying, he is possibly urging before the Honorable Court that your lordship should conduct a trial and take evidence and decide.
I will not do that. That's very clear.
What he has done. Next line, your lordship will see, he has described himself as son of Raghunath Samantrai.
Mr. Mishra, he is only seeking time to decide whether he is Ullas or Hrusikesh.
I'll file certain documents.
Can it be done, my lord, in 480?
Next date of hearing that no, I am Ullas only.
I'll file certain documents.
My only thing is that not only he has described himself as son of Raghunath.
That is the only.
But why have you not settled the dispute when I sent it to mediation? What was the problem?
But I am agree. Now I am 82 years.
No, my lordship may see the report.
But
what was the problem in the settlement?
No, my lord, his whole intention is to grab the property of Loknath, though he is not heir of Loknath. He, knowing fully well, he has described himself as
that issue has already been settled in the suit.
He agreed for a
that
settlement.
issue has already been settled, and he has also filed another suit which is pending. The mother had filed in the meantime. The mother is there.
You can't find out a middle path.
It should be. It should be because
He will not.
But what has happened? They claim some property. Huge properties were given. All the sons they sold it. Now they're trying to grab some other property. That is the
But fact is, neither your property nor their property.
no,
It is the
that
property of Raghunath and
no,
Loknath.
they are not concerned with this property. They are not claiming that
But I
property.
am daughter of Loknath.
They are not
I am
claiming
daughter
that.
of Loknath.
I thought that better sense will prevail both of you to settle. You are not settling. It's all right.
He did not agree before
We'll
the
hear-
conciliator.
January of the yes. 101.
Head 1 Miller. The 202 inquiry is made for the purpose of deciding whether or not there is sufficient ground to proceed against the accused. Here in this case, your lordship kindly have glance. Annexure 7, the complainant refused to adduce evidence. That is page 40. Ordered 17/4/2017. Advocate for the complainant is present and files a memo stating that complainant does not want to adduce evidence for inquiry under section 202 CRPC. Hence, the inquiry under section 202 CRPC is closed. Put up on certain days for hearing on the point of cognizance and has taken cognizance. Before that, I am submitting your lordship, kindly glance. The entire order sheet, your lordship, the initial statement itself has not been taken. Your lordship, page annexure 7.
Yes, Mr. Depat, what?
Lordship, kindly have.
How do you sustain it?
But initial statement is not necessary.
In 202 also not.
Not 202 inquiry, it is the, my lord, prerogative of the magistrate, my lord, whether he wants to take the witness on oath or not. And I have filed a complaint petition. Once I file a complaint petition, basing upon that, my lord, he can.
He can.
Yes.
If at all there is a case made out.
Yes.
Because this is FIR charge sheet was already filed. Huh?
No,
No,
it is a
complaint
petition. And I have filed a complaint petition with the evidence on affidavit, my lord. I have
Then
filed
the
it.
court was satisfied that
Yes.
case is made out from the complaint.
Complaint petition, then no necessity of
202 is not necessary always.
I'm
Mandatory, your lordship.
Let us
202, your lordship, this provides your lordship, kindly glance. Provided that,
Yeah, 1 minute.
your lordship,
Yes. Yes, sir.
two provisions. 202 subsection 2 provision.
Hmm.
Provided that if it appears to the magistrate that
Yes, there the catch lies. It appears to the magistrate. There the catch lies.
that appears that the magistrate that offense complaint of the tribal exclusive by court of session, he shall call upon the complainant.
No, what is Mr. Tripathi says, if from the complaint itself, a prima facie case is made out, 202 inquiry is not required at all. So they can
No,
proceed.
202 inquiry was made, but he refused there.
That's
Question is that, besides that, I have other 2 points. I am coming to that. Your lordship, kindly glance first on that issue. Your lordship, the annexure 7.
What then you are saying that once the court says that 202 inquiry is required and ask the complainant to adduce evidence,
And he
that
refused.
means he was not satisfied prima facie that the case is made out on the basis of complaint.
Yes.
So thereafter you say no, then there is a
Yes, that I am saying. Besides that, your lordship, the initial statement is required to be taken. Under section 200, if a complaint is filed, the lordship, that is some irregularity in the proceeding, your lordship. The first, page 39, the first order, your lordship, 27/3/2017.
I'll give opportunity to him to resort to 202.
Then he refused, you have finished 97.
You can do it, what is the problem? You yourself has said that there is a procedural
Irregularity.
irregularity.
Yes.
I'll allow him to correct it.
And the
Procedural irregularity can be corrected.
and the initial statement also not been recorded.
I set aside it and send it for.
Yes. And besides
you do it, but see, eventually you may have faced the problem.
Yes.
Better that you should do it.
No, my lord. What happened, my lord? Witness was examined.
No, witness is not. You said no, I will not examine.
No, witness was
I am reading the entire answer to Annex 7.
Or somewhere,
That the,
nothing.
that the complainant,
You, unless you are reading too much into it. 202 is done and we want to do.
202 super,
You tell me whether case is made out or not. On merits, you tell me.
or provide me installment so that balance amount I will pay. We allow.
No, how can I go into all this
That
nitty-gritty
is so
factual disputes and all?
Position is there.
With your lordship permission, my lord. This 2017 matter. Much water flow in between the years.
Shall I send it to mediation? And
Yes,
change
yes,
the- Why?
I am praying that.
Unnecessary getting into all this.
Send it to
This is what conjointly both the petition.
No, well, may I pray, my lord? This from Rourkela, sir. Rourkela is mediation. That is Suvidha.
Work it out. More after some argument, both the counsel appearing for the parties have conjointly stated that since the dispute is minor and there is a scope of out of court settling. Hence, they request to relegate the matter to the district mediation center, Rourkela. District mediation center must be Sundargarh.
Sundargarh, the district. Rourkela.
Let it be Sundargarh, nearby only.
Nearby. Sundargarh.
Sundargarh.
No.
Awaiting the review. January?
Will also dispose of this matter.
No.
That model.
It is pending, the entry model will continue. Entry will continue and awaiting the mediation report, I'll just put it in the first week or second week. I'll just come. So take the group has on the from the office. Not tomorrow. Who is it? He said already. So let it be on Friday then. Tomorrow you have to the same story after lunch. Then let it be after January. Okay. Entry more to continue. Yes. Yes. 60 years.
As I mentioned, yes, because the informant of marriage recent members, he has gone to Bangalore with his husband. Then I this was really a problem to know say as personal appearance.
Yes. Next. 376 without very, victim. Where is he?
My name is
Just take it up. What is your name?
Sankar. Yeah, I have given information.
No, that appearance we think about, but very good. Team.
676. Madam.
Yes.
Various sections of the Indian Constitution. My challenge is confined only to the
307, not made up.
not made by.
That's what it is. Yes.
Remember, the 2007 is confirmed. The allegation is the petition number 2. Appended to fact from the constituted picture. That is allegation to constitute the opinion section 300. To that matter, the consummate pistol was alleged seized. And PW1 was a witness to the singer. His evidence was recorded and it was filmed. Who said nothing had been known at page 16. 16. It said that something pistol was therefore, and moreover, no firing did take place, no injury, no. So from the consummate pistol was seizure was found to be false. So only with regard to 307, I challenge to the.
No, the evidence, trial is going on now.
Though the occurrence took place in 2015, the PW1 was examined in 2023. This is only evidence.
See, some evidence has come, charge has been framed against you, 307. And how can I scuttle the trial and appreciate the evidence at this stage and say that 307 is not made out? I know you are reading evidence, and I read it.
Yes, he said.
Can I appreciate the evidence?
I have said that there is no seizure witness.
I know, I understand it.
Yes.
But these things has to be done by the trial court only. I can't appreciate the evidence which has already come on record in a 482 proceeding.
That evidence is no seizure.
I understand. I can see it straight away. No case is made out.
Yes.
No problem. But in a 482 proceeding, I can call for the all evidence, start recording an acquittal in your favor.
And from the charge sheet I filed, the injury reports are there. No.
I understand.
Nobody sustained any injury.
But since the trial has already commenced, evidence is being recorded, and nothing has come on record against you, then the right course is there to, I will expedite the trial. That's the only thing I can do.
The occurrence took place in 2015.
Whatever, I can't help it.
Evidence.
I can't help it. Petitioner is in the present petitioner is exploring the following prayer. Following the prayer. In this case, after charges are being framed against the petitioner for various offences, including the offences punishable under section 307 CRPC, and evidences of the witnesses have been recorded. And counsel for the petitioner taking me to the evidence of PW1 with the seizure witness have submitted that the seizure witness have not supported the prosecution. So therefore, the country-made pistol, which is supposed to be alleged to have been used for commission of offence, has not been proved. Therefore, he submits that insofar as the charges under those seven IPC is concerned, the same is not made out. I am not inclined to include this petition at this stage because the trial in the present case is proceeding at the next 15 days, and the evidence have come on record. By exercising the jurisdiction under 482 CRPC, at this stage, this court is forbidden to appreciate the evidences by scuttling the trial in between. Hence, I'm not inclined to entertain this petition. However, liberty is granted to the petitioner to reach all the points before the court below. If such issues are taken, the same shall be considered by the trial court on the basis of evidence. That would evidence on the basis of the evidence on the court. Yes, that I have said. Yes. 80. Yes. 80. 80, yes.
May I please?
Yes, sir.
On the FIR lodged by one.
Custody?
Custody. Prisoners are in custody.
You have case diary and all, everything is there. Ready?
Earlier it was also granted the same PS.
Other coactive.
Granted the bail. to the
Other
coactive.
coactive stands in the similar footing and
Similar footing. Just take
That
it up.
flag-
সেটা খালি ইয়ার কষ্টে গিয়েছিল বেসিং
minute.
upon কার্তিক মাঝি স্টেটমেন্ট the coactive
Dilip Maji.
মালম
You are in custody since
19/9/2023 চার্জশিট সাবমিটেড
2024.
23
Yes.
own confession before the police of Kartika Maji.
On suspect, they have been.
There was a delay near about 6 days of the
What are the allegations against this accused?
allegation against the present petitioner that
Yes.
they suspected that there was a
Read out the evidence. Eyewitness? No eyewitness.
No eyewitness to the
What is the recovery from him?
That CD was available with that bail application.
You just tell me what have you recovered from these two witnesses, these two accused person. Section
No.
27 you have invoked.
No, there is no weapon of offense was used.
But what have you recovered from these two?
No
Nothing
recovery.
recovered.
Shall I record it?
Yes.
Huh?
Yes.
Mal.
Petitioner is accused in so and so. Okay. Allegation of the
Recovery.
petitioners, and so and so. It is the co-accused in the present case, co-accused Dilip Maji, in the present case applied for regular bail by filing BLAP number 2212 of 2024. 24. This court by the order dated 24/9/2024 has allowed the petitioner from bail.
Own confession.
In the present case, there is no direct evidence available on record against the present petitioner. Similar was the case against the co-accused who has been enlarged on bail. Mr. Vishwan will talk about the state submits that there is no recovery effected from either of the accused, either of the accused. It has regarding to the period of custody from 19/9/2023. What is the stage of the trial?
Charge sheet submitted, my lord, and case has been committed to the court of sessions.
Although the charge sheet has been submitted and committal proceeding has taken place, but the trial has not yet commenced. The trial would take considerable time. Hence, I am inclined to bail accordingly. That's correct. Yes. We'll call immediately. Finish.
19.
My lord,
yes, sir.
I am appearing in this case today. So let it come in the next day.
You are appearing for?
Opposite party number 2.
So entered appearance for opposite party number 2 and seeks an adjournment to file a reply to the petition. Lease the matter in February. Interim order to continue. Interim order dated.
It is dated 24/7.
24/7/2024 shall continue. Yes.
102.
My lord, this is a vigilance case and there is another connected matter arising out of the same affair. CRL REV 511/2024. It has been adjourned to 13 January. So, my lord, this CRL
13 January, along with that.
criminal revision 511/2024.
13 January. Okay.
103.
103, my lord.
13 January. Yes. Yes. Yes.
103, may I please, my lord.
103, na?
My lord.
My lords, this case pertains to institution of a second FIR on the self-same cause of action on basis of a complaint case filed before the magistrate, my lords. My lords, may
I have already contacted and very soon he's going to send. On the last occasion, the kindly see the noting here. The last occasion, it was directed to get instruction in the said matter. In pertaining to this case number 79 of 2016.
Mr. Tej Pratap, that comes, but the state submits that he has not received the instruction from the investigating officer, hence seeks an adjournment, leaves the matter in January. The interim order passed earlier shall continue.
deeply obliged, my lords.
104.
And I'm on behalf of Mr. SS, this kindly be taken up after lunch.
After?
I will pass over this item.
So rock this adjournment on request for adjournment. Interim order to continue. Yes.
105.
I am on VC for the opposite party number 1. I've talked with my learned senior. I am filing the affidavit within a day. 2 for the opposite party number 1, and it may be taken up. Interim order is in their favor.
Yes.
So it can be
Let
taken up.
it
come
then after vacation.
Our mood nahi
Mr. Somki's
Mr. Rajiv Rath.
Appearance for opposite party number 2 and seek an adjournment for filing response to the present petition. Leaves the matter on such date. The interim order shall continue.
Right.
Though January, second week, third week. Take.
But it's Rajiv Rath, not Somsekhar. Wrong way.
Sorry. Yes.
6.
May I please, your lordship. My lord, in this case, Senator, I challenge the charge framed against him under section 120B alone. Okay. And that too is, there are 4 accused persons. Out of 4 accused persons, 3 are already dead and the case has already been abated against the 3. Primarily, a charge sheet was filed against them under section.
See that judgment you are showing.
No.
Only 120B, what revise? 0?
How 120B will survive, my lord?
No, simpliciter 120B you can, but the two conspiracy.
No. That is not the argument. That is the law says that if any person dies, then the case will abate against him. That means who? That means what? No trial can be.
Sir, you address the court
because the
2 accused have died.
Yes.
All
the 3 accused died.
Including the petitioner.
No, there are 4 accused persons, man.
Let us understand.
All the 3 accused persons.
There are 4 accused persons.
Yes.
3 died. And you are alone.
I am alone.
You have been prosecuted for 120B. That's what your case is. Okay.
That to which 120B is the ingredient.
Let us see the allegations.
What is the actus reus, my lord? There is no actus reus.
Let us see the allegations against you.
Allegation is that that I have taken I am a contractor, my lord. I have taken the part bill of the running bill. The bill was not finalized.
Yes.
And when I am taking the running bill, only after 2 years of execution of the work has to complete it after another 5 years. But when I was executing the work, they have put a vigilance people for investigation and they have filed a FIR against me and I bailed out and thereafter filed charge sheet against me under section 420 and also 120B. 420 has been, your lordships may kindly have a glance to the order passed by the Law and Trial Court.
Yes. What is the stage?
Pardon, my lord?
Stage of the trial? Trial?
Date of the order.
No, trial stage.
Trial stage, the evidence has not yet begun. In the last occasion, the trial judge noticed the witnesses to be present on that day. The date was 5th and 6th, my lord. That is my instruction, my lord.
Okay.
My lord, may I read that person? Your lordships may kindly turn my input order.
You have taken the excess payment of 11 lakh
11,34,990
rupees.
Yes, yes.
And thereby committed an offence under section 120B.
Yes, that is the allegation.
Yes.
But my 15 lakhs rupees as surety is deposited with them. Basing on that, I was bailed out, and basing on that also, that was observed in the when I came for passing of the prevention of corruption charges leveled against me. That was also passed out by this Honorable High Court. And thereafter, at the framing of charge, I filed a petition to discharge me, and that petition was taken into consideration, and that petition was also been dealt with by the London trial court. Your lordship may kindly have a glance.
Yes.
The record is
15 lakh security amount is lying with them.
Yes, yes. Not only 15 lakhs. My final bill has not yet been paid. I have taken the contract for more than 25 crores.
Yes.
Your lordship may kindly see that as per the prosecution allegation, my lord got it to the input order, my lord.
Yes, I'm there.
Input order, my lord.
Yes, I'm already there.
May I read it, my lord?
Yes, yes.
As per the prosecution allegation, the construction work of so was entrusted to the petitioner's company.
Yes.
And it was been entrusted by the executive engineer as well as the assistant engineer and the junior engineer. Thereafter, I am coming to, because not to it was dictated that due to substandard work executed by the contractor in connection with the items such as failing with the moral substance, he has taken excess in running bill in 11 lakhs 34,990. That is the allegation.
Yes.
And I am coming to that. The cognizance of the offence against the para 2, my lord. The cognizance of the offence against the accused persons being taken by this court on 27/2007, while the matter was pending for consideration of the charge on 4/9/2010, the above two petitions under section 227 CRPC was filed by the respective accused person to discharge them the alleged charges leveled against them. And the accused 1, 2, 3, they are the main accused persons. Allege that the present case instituted against them is premature as per the agreement, since the work in question was to be completed by 2005, my lord. It was a case of 2003. And further, final payment in respect of the said work was not made till the institution of this case, and hence it is not correct to state that the amount in question was paid to the contractor in excess. That part, there is absolutely no prima facie case against them for the alleged offence. In the face of the material available on record, hence prayer is made by them to discharge them in the alleged offence. The other co-accused person, so and so, name was not mentioned in the FIR, but in the filing charge sheet, it was figured in the charge sheet. That is the accused number 2, who is the power of attorney of the petitioner, my lord. So there are two petitions here. And he was not named in the FIR, but at the filing of charge sheet, he was named.
Yes.
And by order of the Honorable High Court in CRLMC 2804/2007, before the Honorable High Court in 482 of the CRPC, challenging the order of taking cognizance, the Honorable Court have quashed the order under section 13(2) and section 13(1)(d) of the Prevention against the said accused, observing that he is not a public servant. It is also alleged that the other accused also is not a public servant.
What do you want to show out of this?
Pardon, ma'am?
What do you want to show?
I want to show that he has convinced that no prima facie case is made out under section 420 IPC. That he has observed, basing on the facts,
Yes.
no case, basing on the, and he has observed that basing on the documents and the witnesses and other things, because the police at the time of investigation, some witnesses have given their witness under 161 CRPC, and also the documents. After examining that, he said no, not only the petitioner, all the three accused persons, 420 is not made out. So 420.
That is the substantive offence for which 120B is.
Only 120B.
The substantive offence is 420. According to you, it is not made out.
Not
That's the
made out.
finding.
Made out.
If substantive goes, substantive offense goes, then 120B goes.
Yes, goes.
Yes.
And that which he cannot be convicted only 120 because that
Yes.
1956 also affects.
Where is that relevant finding?
If findings, my lord, your lordship may kindly turn to. Your lordship may kindly turn to. I'm reading that person. Similarly, from their alleged overtaxed act as well as conduct, they appear the prima facie material against them under section 120B. And so, but so far as alleged under section 420 IPC is concerned, neither the FIR nor other materials and record prima facie disclosures about the involvement with the said offense. As such, the said accused persons are
These are your submissions.
Yes, that
Show me
no,
the
no,
finding.
liable to discharge. As such, and he has said that I have discharged the person. My lord, may turn to. Yes, your lordship may turn to the next para, middle. Thus, in absence of any material, my lord got it.
Yes,
in
sir.
absence of any material or even strong suspicion against the above two accused persons with regard to the alleged commission of offence under section 420 IPC, no charge can be framed against them under. However, from the FIR as well as the other materials and record, as mentioned above, it reveals that the present accused persons by their conduct entered into conspiracy with the other accused persons for undertaking the substandard work in question, thereby putting the state to substantial loss. In this regard, it is to mention that the direct evidence of conspiracy is seldom available, and many times the offense of conspiracy has to be inferred from the proof fact. Taking aforesaid fact circumstances into consideration, there appears prima facie case under section 120B IPC.
Come to page 24.
Yes.
Last paragraph.
Last paragraph.
Read it. From the above materials.
Pardon me.
Page 24, last paragraph.
The present petition was
No, from the above materials. It is clear that the accused person number 1 and 3, namely so and so, so and so.
Yes, yes.
Read it.
As indicated earlier,
as happened, the public servant
on perusal
further
of
said material involvement of the said accused persons
of
with
the person those who are dead.
LS offense under so and so, as well as stated. It reveals
there is sufficient prima facie material
Yes.
under 120B against the accused person.
Yes.
And
Right, read it further. It reveals that they, by misusing the position as a public servant, showed favor to the concerned contractor, that is you,
Yes.
and allowed the execution of substandard work, thereby putting the government to the pecuniary loss to the tune of so and so. Similarly, from their similarly from the alleged overtake as well as the conduct, there appears prima facie material against them for the alleged offence under section 120B IPC. Have you got it?
No, man.
That's there, 25, page 25.
Page running page 7, 8, my lord, I'm reading.
No. Your petition, page 25.
My petition.
Ready?
Yes, page 20.
How will you answer, Mr.
Hence.
No, there is a finding now. This finding, have you challenged this finding? No. See, the finding is 120B is made out. Okay.
No. Chalo, diya is upon
1 minute. See, the second part, the second part will create problem for you. 120B is made out, no problem. But the finding is, have you challenged this finding? But so far as the alleged offence under 420 IPC is concerned, neither the FIR nor the material on the record prima facie discloses about their involvement with the said offence. Then if 420 goes, 120B goes. That's
If you need 120B for self-same offense, 120B, they can
conspiracy to do what? To commit a substantive crime.
Yes.
31D have been committed by the public servant.
Where is 13(1) finding? Let us see.
Your lordship can page 6.
My lord, probably my
The
lord.
court prima facie discloses about involvement of application. So as far as the
It's
is
like
liable
that.
to also.
120B, I am liable for 120B, I am charged for 120B. 120B is not a substantive offense.
Though it has been mentioned that
cannot be wrong.
provision as well
Independent.
Yes.
Its case is that.
Yes.
That in this case,
Has been passed by the rules of the court also.
last for our court to that.
No. In so far as 13(1) and the 1D is concerned, 13(2) and 13(1)(2) is concerned, that has been quashed.
Yes.
That is quite in respect of the present petitioner because that cannot be attributed to present petitioner.
No, who has filed this? Oh, he Ashok Jalan. Who is he? Ashok Jalan.
Yes. Petitioner.
See, now, this honorable court,
Hmm.
once they held that 420, 120B.
Who is Arun Kumar?
Is the attorney, power of attorney of the petitioner. His name was not in the FIR.
Okay. Yeah. Yes. Show me now.
This court,
Hmm.
120B is like, is attracted to them.
Not liable, but you can move the petition.
Then what is this finding then? What is this finding? Page 6 of the petition. Hmm.
Second paragraph, last letter, therefore the court.
Okay, it's
But when the allegations are about conspiracy. Second paragraph, last part.
Page 6.
Page 6, second paragraph.
Admitted position, huh? See paragraph.
Last paragraph.
Yes.
But when the allegations are there about conspiracy and loss to the state exchequer by conspiracy.
The cognizance so far as 420 APC cannot be quashed. Okay.
Therefore, the cognizance of section 31B of the Prevention of Corruption Act against the petitioner is quashed, but the order of cognizance for other offences are sustained. So now, this one.
Then what? This is the order passed by this court in this criminal case. That is 2000.
So this honorable court was not inclined to quash the proceeding in respect of 420. So now, it said he filed a discharge petition and 420 was deleted. So one petition was and 120 remains. 13(1)D is also remains in respect of public commission. So now the question is, she is saying that if his case is, so what I understood, in absence of them, how I face 120, 200. So what 120B is concerned, first of all, is he is challenging the charge. So when a charge is concerned, this honorable appeals court has held once charge failed, 420, 482 cannot be accepted. Another aspect, charge is revisable. He has not preferred division, he has filed 482. That is not mentioned. Number 3, that is in respect of.
You show me one judgment where it says that the substantive offense goes 120B, even then 120B. It's gone.
Against it. Maybe he is not liable from the 31B.
I'm only testing his case today. His 13(1), 13(2), 13(1)D goes. And 420 also goes. Then simpliciter 120B. In the absence of.
My lord, this
because case has not been tried. Some public servants have died. In that case, in the case of Jitendra, is the last occasion,
What you are trying to say is, since 13(2), 13(1)E, so far as the public servants are there, that substance, that allegation is still there. Vis-a-vis that offense, 120B can be tried. That's what you are saying.
The judgment of the Honorable Appeals Court in that is clear. That is in the case of Jitendra Singh.
Yes. Yes.
Jitendra Singh's case. There, my lord has said that. Conspiracy for any offense, either under PCR or under IPC, it is separate offense. Has to be separately.
I understand it. You say that he has conspired with the public servant, those who have died.
For example.
So therefore, 120B still continues.
There. So he has to tell that.
Yes, I understand.
Another aspect is that a recent judgment, Supriya case, my lord has also held that.
Show me.
That is.
For 8, huh?
18.
18 one. Yes, read it.
18.
Applying the broad principle. Credit court, we hold that. No.
Right, it's tried that. The conspiracy commission by saying distinct from the offense to do which conspiracy entered into and that sort of thing. So the 120B is concerned now of the statute. Even if the offense is not committed at all, the conspiracy itself for that purpose he will be liable. I show another thing on that one.
This is impliedly this can be utilized.
Each stage, at
Well,
each stage,
well,
whether
your-
conspiracy.
Yes.
One thing I must clarify, Your Lordship, this is misconceived because of the fact I have come against cognizance, not against charge frame earlier. Earlier, the Honorable Court said that I am not going to pass the cognizance taken under section 420.
Therefore, you went to the charge code. Charge code said that no, 420 is not made out, only
Yes.
120B is made out.
That now he wanted to impress Your Lordship.
Now you have to satisfy that 120, even 120 is not made out. That's
Yes,
what the
120B, there are, because the ingredients are, there not only means they are manner, there must be actus reus. What is the actus reus manner? When the, in the absence of actus reus, can it be construed to be?
Show me any judgment.
Manner, Your Lordship, I have started a written submission before the
yes
this court. I have also have your Lordship got the written submission filed by me? It is in record manner. It is in the file.
Yes.
In that case, I have also given the citation in 1956, 1955, 56 Supreme Court 33, 120A and 120B, conviction of one person for conspiracy, not sustainable. That is from 1956 Supreme Court, page 33. That is still continuing. And thereafter also I have given another judgment of our own High Court, where 420 and 120B was there. My Lord, got my citations.
Yes, I
annexed
got
to
it.
my submission, my Lord.
Yes, I got it.
My Lord.
Yes.
May I read para 6, my Lord?
Para 6 of your the judgment.
Yes. Criminal conspiracy has been defined under section 120A Penal Code when two or more persons agree to do or cause to be done an illegal act or an act which is
That's
not
what he
illegal.
says. But 2 and more person means the people, the government servant, those who have died.
Yes.
Along with them, you have conspired.
Maybe.
Charge,
but
charge in so far as
no,
those
maybe
government servants, those who have died, that charge is not gone.
cannot be done by presumption, my Lord. There must be.
Then that will be tested in the trial.
Because my learned friend submitted by presumption. That is in the trial, my Lord. Because my submission is that what is the iota of evidence or actus reus acts required under law to be established by them? There is nothing. Because when there is, if they would have been there and they would have been convicted in either of the offences, and one
they can get that is their problem. They will get evidence.
Yes, that is their evidence. But
in any case, even if they would have been there,
yes,
even if they would have been there, can they ask this co-accused person, have you conspired with him or not?
No.
The evidence will be otherwise.
No. That is
whether they are present or they are not present makes neither here nor there.
No. That is different, my Lord, because in the trial
their case today is you have conspired with the government servant.
Yes.
Those who have expired.
Yes.
For
what? For my financial gain?
Yes.
What is financial gain? 15 lakhs is deposited with.
Then again you are going to merit, son.
No.
No.
Fact relates to the law, man. What is the fact of this case? Every judgment relates to facts, my Lord. If fact is from case to case, it varies.
The fact is, without working, excess bill you have raised and taken the money.
No. Here
conspiracy with the engineers and all.
As per the
that's the allegation.
No. As per the note, the PWD book of submission of bill, I am entitled to get running bill of 20% to the entitlement, my Lord. That I have avoided in my petition also.
Show me the contract.
Contract.
Show me the contract.
Contract, lower court records can show because contract.
The contract by which you enter into the work.
Yes.
Whether there is a condition that if you have taken excess payment, it will be adjusted in the final account. You show me that, you are out.
I'll show that.
As simple as that. Because 15 lakhs is taken as a security.
Yes.
And the allegation is you have taken excess money.
Yes.
Okay.
Yes.
If you have taken excess money in the contract, if there is a condition that it will be adjusted in the final stage, and that money will be adjusted and you are out. Show me the contract.
Kindly pause a moment here. That is excess money to the entitlement up to 20% of my running bill. That is the running bill. That is not the final bill.
Actual dispute, I will not go into it. Show me the contract condition. You are saying that the excess money, even if I have taken, it can be adjusted in the final stage, or it can be adjusted with the security which I filed. Show me that condition.
That I'll contract. Show you. I can show you. I'll bring this.
Then
That is, even if the acquittal of other person.
that's right. That I know. And the judgment which you are citing, those judgment may not help because of the stand taken by them. So therefore, you have to show me prima facie that there was a precondition. So there is no conspiracy. Even if I have taken extra money to cover up that, I have given security of 15 lakhs. And there is a condition that if I have wrongly or rightly, if I take extra money, because it is a running bill, it can be adjusted at the final stage.
Yes, yes.
Then you are out.
Yes.
Where is the question?
That I can show you also.
Yes.
Your Lordship may put it on January any day.
January 1st. Yes.
May I pray one thing? Further proceeding may be stayed.
No. You are not able to satisfy. I have not given the entry order earlier also. Because you could not satisfy, therefore I will give entry order.
That is the case.
Yes.
Your Lordship may call for the records because if the records will come, that the contract is there also in the record.
You file, you substantiate.
I will definitely.
You try. If it doesn't happen, then
a copy.
87 compromise. Yes.
87. Yes.
87 compromise. Yes.
Can I pray before Lordship? 1 second.
I'm not raising it. 87 is a compromise matter. I'll just take because 107.
That is regarding the acquittal in department proceeding and with the criminal.
107 note kar rakho. Mr. Das request kari kar rakho.
107.
On that day, Your Lordship, Friday.
You bring the I'll just adjust the date and I'll give you. Okay. Bring that contract. Let us see. Yes. Yes. 87.
Yes.
What are the offenses, sir?
294, 323, 506, 341, 553.
Yes, Mr. Vishal. Any legal impediment? What are the allegations?
Regarding the bill we are spending for the JE, petitioner had gone to the office. There is a certain quarrel between the petitioner and the JE.
JE?
Petitioner is a contractor. JE the informant. And he has kept some bill that has not been passed by the department. He went to the office to request him to refund the amount. There's a hot exchange of words.
Then you have beaten him.
Not beaten, the allegation is there.
Earlier you have beaten him, now you paid money. That's the difference. Still you are a contractor, he is an engineer. And you want to continue this relationship.
Yes, sir.
Yes, right now. At the instance of opposite party number 2, the FIR number so and so came to the state. What is the stage?
That's it submitted, cognizance taken.
The charge sheet in the present case after investigation was submitted
That
on
case,
3 for alleged commission of offences punishable under 341, 294, 323, 506, 34 and 353 IPC. Subsequent thereto, the trial court by order dated 13/1/2023 has taken cognizance for the offences as mentioned above. The case has not the petitioners has not put to trial as yet. When the matter stood that, the parties have settled their dispute and filed the present petition for quashing of the entire criminal prosecution on the ground of settlement. Who are the petitioners and
petitioner, yes, madam.
their present? Moisar Malik, Manas Ranjan Malik, and Baribandhu. A joint affidavit has been dated 9/12/2029 has been filed by the parties in stating as under 1 and 2. On the query from the court, the opposite party number 2 submits that he has settled the dispute with the petitioner due to on the intervention of well-wishers and common friends. Common friend. He doesn't want to proceed against the petitioner anymore. The Mr. Vishwan, let me counsel for the state court, submits that the allegation, the offense is primarily interested party, and since they have settled their dispute and by appearing before this court made a categorical statement that don't want to the opposite party number 2 made a categorical statement in the court that he doesn't want to proceed against the petitioner. There is no legal impediment in watching the FIR regarding it to the nature of offense and the fact that the opposite party number 2 has filed an affidavit before this court and has also made statement before this court that he doesn't want to proceed against the petitioner. It is apparent that subjecting the petitioner to it is this time that the trial would exercise of the trial would destined to be a futile exercise, destined to be a futile exercise. Hence, the case of the petition are covered by Jan Singh Institute. And hence, I am of the opinion that the petition deserves merit. Accordingly, it is cost. How much they will pay contractors? Where is that? Where is that affair? Baramba means Kotak Bar Association let them pay 5,000 each. 5,000 each. 10,000 rupees Kotak Bar Association. Subject to petitioner. 5,000 Bar Association. 5,000 each to Bar Association Kotak.
Total 5,000.
5,000. They were contractors. They beaten up the engineer.
Not beaten up.
5,000 to the bar, 5,000 to the opposite party note. Yes. Yes. Next.
108.
108. Pay 5,000 to
Mediation date is fixed to 13/12. Mediation date fixed to 13/12.
It's an awaiting mediation report. Mediation is fixed.
Mediation report is there, my lord.
No, 13. Date is fixed. 13.
Oh, another date is fixed.
After 13.
My lord.
109.
First week of January, Mr. Chow. Let it be in first week.
My lord.
First week of January because entry mode to continue.
My lord, I am for the OP. The petitioners are not this.
It may be settled also.
My lord.
If it is settled, then you mention before,
definitely.
so that I can dispose it. If it is not settled, then on merits we will hear it.
Grateful, my lord.
Yes.
109.
109, my lord, I am for the informer.
Yes.
My lord, can you see the order dated 13th September
Yes.
2024? Petition is not there, my lord.
Even today, petition is not there.
Regarding that land matter, the land dispute between two parties.
But the petitioner is not coming for what to do.
My lord, in the meantime, charge already been framed and out of 6 witnesses, 3 already examined. my lord.
Also appealed for opposite party number 2 and points out that on the last date of hearing also none appeared for the petitioner. None appeared for petitioner. None appeared for the petitioner. Since the petitioner has not been appearing in this court, it seems the petitioner is not interested to prosecute the present case, and hence the petition is dismissed. Yes.
110.
Please, Your Lordship. Mediation has failed, my lordship. Look at the report. We had agreed to pay certain amount. So we could pay only 1.5 lakhs out of 18 lakhs. And they were demanding 4 lakhs further. We offered them 2 lakhs. Kindly wait for some time. They refused. So mediation failed. So now maybe Your Lordship has to hear the matter. But you are not interested for mediation? The total check amount is
My lord,
17 lakhs amount. How much you have agreed to pay? 18.
out of 18, he paid 1.5 lakh.
That is the
Rest
report.
16.5 lakh was there. He agreed to pay 4 lakhs on the last date, and rest amount will pay another date, but he did not pay.
As it happened, my lord, this relates to a sale deed executed by a third party, the agriculturists, in their favor directly. Now, my lord, his client had given us some advance. So since he was in a hurry, we got the sale deed executed. Later on, she said that no, I am not interested for this amount, this land anymore, and he started creating all sorts of pressures. Accordingly, I issued him the check. This is part one. Then, my lord, this opposite party number 2 husband, with his ages, another property has been purchased at 43 lakhs on behalf of opposite party number 2's mother. That also money she demanded, which you have paid back her directly. She is not coming forward to execute the cancellation deed. So what we talked in the that my lord, mediation center, that you call her over because she has already received the money, let her cancel that decree, sell it, my lord, and you also cancel it, give us a date, we will pay you the entire balance amount on that day. Primarily, we are paying you 2 lakhs today. That was not acceptable. So here, your lordship may have to hear the matter, or else they will
My lord, that is altogether a different transaction. That transaction has got no nexus with the present.
True.
That was
her husband has got 3 lakhs rupees from us in consideration of
This is
that.
a case arising out of a 138 procedure.
My lord.
Sir.
I have to just see whether you have issued check or not. If you have issued check, then you have to face sort it out, or whatever defense you have.
He agreed to issue, even after registration of the land, my lord, he agreed to issue pata, but there is some dispute over the dispute.
No, there is no pata dispute.
For
Who wanted
that,
the money?
that is the reason, my lord. He said that as because I am not able to issue ROR, for that.
Then 1 lakh, how much you have paid? 1 lakh?
1.5, 1 lakh 50,000.
Oh, that will suffice for the purpose of 143. And
143 also we paid separately.
Over and above that, you
pursuit
paid.
of lordship direction, we have deposited. What I am submitting, my lord, I will argue on this check bounce case. Your lordship may call it next week.
Okay.
My lord,
Or any
I
date that you want to continue, mediation failed in the present case, and release the matter for hearing on such a interim order.
Before vacation, my lord.
Before vacation, we'll see. 23rd.
Before vacation time, anyway, date.
Yes, next.
111. So that matter pertains to those vehicles where there is absolutely no material, the charge sheet and the FIR. He is not on the FIR, no material in charge sheet.
Yes.
Documents, petition is relied, that is not part of the proceedings. Number one. Number two, the document petition is relied, that is self-contradictory. So it's a disputed question to be tried.
You have pointed out so many things.
May I say something?
And the money now is the extent that I have obtained loan and I have that by your finance, I have that vehicle. But the document they are relied, so otherwise. And all the instruments, check bounce, then cash has been paid. All the instruments in respect of all the things. So it shows now this question here, it's a case of disproportionate asset. He has been entitled on 620. So he has to pay the bill and he has to show the sources of income. The income and I got the return and the inflows where from he brought that cash. It's not a matter of thousands or lakhs. So he has it's all.
May I say something? Which document he is talking about? His own document I'm asking. Let him show a scrap of the paper that these vehicles were my vehicle, or there is any scrap of paper in that charge sheet. Forget my documents, Michael, for a minute.
I think if I correctly remember, there are 3 vehicles.
4 vehicles.
4 vehicles.
Interestingly,
and
4 vehicles.
You said that I have obtained, I have purchased those vehicle on by taking loan.
Those things, my lord.
In his charge sheet, no evidence, no witness, no document regarding me. Let him show one paper, I'm out of the court, my lords. One single scrap, I'm out of the court, my lords.
Let us go to charge sheet now.
Please, lordships.
Let us go to charge sheet.
My lords may first go to the FIR, lordships.
FIR forget now.
In FIR, I am not named as accused. My trucks are not
Because
listed.
the prime accused is the.
My lords, my trucks don't feature in the list.
You have been prosecuted for.
Only because the suspect officer's wife is using a SIM card issued in my name. That is the long and short of the allegation. My lords, in the FIR, my lords, why I am saying FIR, lordships? Because in FIR, I am not named against any vehicle, my lords.
If you are with the wrong company, then you are bound to face
My
it.
lords, that is different story altogether. My lords, the charge sheet has to follow some procedure.
Show me, let us see.
My
Let us
lords, may
see
come
charge
to
sheet.
the FIR, my lords.
Can we finish within 10 minutes?
My lords, this has been continuing since 6 months, my lords. 8 months, I would say. I am not addressing you, I am telling the court.
What to do now within 10 minutes?
Yes.
When is it?
I'll
Give the date.
3815 of 2024.
At least the present matter along with 38 also. And next week, the next
My lords, can it be on 18th?
18th.
18th.
Let it be 18th.
I am coming on 18th.
Yes, 18th. 18th. Let us see, we'll try. We'll try because he's coming to then.
My lords, in spite of paracetamol, I am addressing you lords because of this matter. I am paid for that purpose. You mean to say? I am lucky.
No, he wants your company. He wants your company, that's all. He says
privileged to give.
And rest of the thing, what you do, I don't know. That is your understanding.
My lords cannot visualize, can't communicate.
18.
So lords, 8. Grateful lords.
Yes. 67. What? Possible? What happened? 67?
Not able to appear.
Urgent. Quickly urgent. I can only adjust your date before vacation. That's all.
311 percent.
311. 311 just see 67.
This is a
NIA case, Miller.
But who is appearing for the other side?
Press matter.
I will issue notice. Notice before vacation day. Notice. 311. Na? You want to re-examine the complainant.
But
he has not prepared any questionnaire, my lord. He has filed a petition. In that petition.
What is the check amount, by the way?
11 lakh. Question never
I issue, you take out the notice and I'll put it this side as vacation. Take out the notice to opposite party. Okay.
Adjournment allowed.
Take out the notice this side as vacation.
Yes.
And the standard order I am making one opportunity with some cost. As simple as that. Neither you will waste the time nor the complaint. Get ready for some cost. I'll allow one opportunity.
Yes.
Bring him. This time. Issue notice 67. Okay. Yes.
112.
Wait, please. Your Lordship heard this matter previously, my Lord. I will sum up my submission within 30 seconds. What happened in this case, my Lord?
30 seconds.
30 seconds.
Because you know, beyond 30 seconds, you won't get time.
30 seconds, sorry,
No.
Question of law regarding indefeasible right, Your Lordship, 167 subsection 2, whether they file charge sheet within 180 days or not. That is simple.
Show me. 30 seconds. Let us give 30 seconds. If
My Lord.
30 seconds convince, then it's all right. Yes.
Your Lordship, on 3rd August 2022, the police investigating officer remanded me in this case. 3rd August 2022.
22.
The IO remanded me in this matter. The PS case number is 224 of 2000.
Forget about that. Yes.
My Lord.
Next date line you give.
My Lord, thereafter filed a preliminary charge sheet on 8/8/2022 against 6 number of accused person, not against me, my Lord, and keeping the investigation open under section 173(8), showing the accused Ashraf as an absconder. There is no name of regarding the petition.
Sonu Mehta was
Sonu Mehta against the After filing of this petition, my Lord, they filed charge sheet around 26 months.
When final charge sheet?
The final charge sheet I have not appended, my Lord, because the date in the month of
date. Your name in the FIR?
In the FIR, yeah. My name is in the FIR. In the month of, my Lord, August 2024.
Yes. Yes, madam. Find out a judgment Saw the line? No, the underlining thing is, if an FIR named accused is there, you have taken him into remand and a preliminary charge sheet is filed without mentioning his name. Subsequently, you file the charge sheet. Whether the date of the preliminary charge sheet is relevant for the purpose of him. This is the law.
So,
1 minute.
my lord, so
1 minute, Mr. Sahu. Let us examine it. Yes. Show me. Let us come to the preliminary charge.
my lord,
Come to the preliminary charge sheet. Page 26. What is here? If he is there, then he is out. 51. Okay.
Person namely under Awasi, Raju and MD Astra confessed voluntarily before the independent witness and executing magistrate and writing party that MD Astra, Mikey, MD Astra, son of MD Astra, Brown, Program had sold the above contraband article that is also by illegally to the purchaser, namely Krishna Gupta Kenya, son of so and Mundu and Asim Tara and Patrapada and Sonuma.
Nice. So, what? What is the material?
Yes, I need some.
yes.
Yes.
Without wasting my lord's precious time, my lordship may kindly come to page number 55, last paragraph. Page number 55, last paragraph.
In financing the above brown sugar illegally and also illicit traffic of the brown sugar. And in my lordship, what my friend is saying, 289 of 2022, that is another case, my lordship. You are considered this is P11 by 2022. In another court, in same NDPS.
Bail recording. Bail remove.
No, in this
bail recording. I am.
In this case, was he taken on remand on 3/8/2022?
Yes, my lord.
In this case,
my lord.
7/8/2020, the pending was filed against this 311 PS. 11/6.
Now, suppose what will happen in the preliminary charge sheet, you say that so far as this accused is concerned, no material is available. 1 minute. Let us examine. I'll have to read it just for a legal purpose. If you say in the preliminary charge sheet, nothing comes out against this accused who was named in the FIR, and you have taken in remand, and subsequently in the final charge sheet, his evidence against him comes. Then what will happen to the preliminary charge sheet? Can it be that date can be reconned for the purpose of 167(2)?
My lord, page number 55, last paragraph.
You have to research on that. You have to research.
My lord, they have taken 5 times, your lordship. Since April, this is pending for consideration of default bail.
Where is your?
I am reading my.
No, you show me. Have you moved application 167(2)?
Yes, your lordship.
Where is that?
Because
you will read it by. No. Then show me. Then I'll go set aside and send it back.
Yes, your lordship.
Show me. On the ground of similar cases pending, 167(2) can't be rejected like this. Show me that.
Page number 145 dated 14/12/2020.
1 minute. Show me.
Page number 145.
145.
Dated 12 February 2023.
Yes.
On the ground of antecedent, they will.
The
relevant part is my lordship, page number 4.
What? Page number? 148. Yes.
It appears that the RU could not appearance or present accused as he was in a joint custody with the Sundar case responsible after moving this to that to take the evidence to him for his demand in this case. On the same day, his prayer was allowed, and thereafter on 7/8/2022, charge sheet was filed by the IO in which this court took the cognizance of the offence on 8/8/2022. On basis of the charge sheet, it appears that the present accused has financed to the purchase grounds of the and accordingly charge sheet has committed biggest under section 21B, 25, 27, 8, 29 of 24. It is pertinent to mention here that the cognizance has to be taken against the offense and not against the offense. Although charge sheet reflects the accused person's name, but there is no mention of specific accused people for which the learned counsel Mr. Patel submitted that the charge has never been filed against the person accused, and since he has been remanded by this court on 17/8/2020. Hence, he may be in this point reported as after his remand. This is the prayer note. He spent more than 1 year in jail custody and still did final judgment has not been submitted by the IO. Mr. Patel regularly relied on the decision. So from wherein it was said that without completing the investigation of the.
No, no, it is not, that is not the ground.
My lord,
150.
not really,
150. You have a difficult case.
my lord, your lord.
Very difficult.
I will satisfy, my lord. Whatever.
Very, very difficult.
My lord, your lordship
And
may
it-
kindly come to page number 55.
Nice. See, the evidence has come. That is the finding. Evidence has come that you are the financier. And the link was not established. Therefore, further investigation of 173.
What
was
submitted
kept
in the
open.
final.
And in the second charge sheet, the link was established. That is the-
Established after
So the
26
preliminary
months, my lord.
preliminary charge sheet, they got that information and the evidence that you are the financier.
My
So
lord.
preliminary charge sheet is also filed against you.
Your
As
lordship,
well as the,
page number 55 for a while, last paragraph, 55, my lord.
try some of the days.
My lord, my lord, 1 minute. I will take 1 minute.
Yes, yes, tell me.
55, my lord.
Yes.
Under the above fact and circumstances, are some action are yet to be complied, that is to receive the acceptance of remand report of accused Sonumata from Hon'Ble Court, obtaining the CDR and this, search of the mobile phone of the accused person with certificate 65B, Indian Evidence Act, etc., and submitted preliminary charge sheet against Angela Varsi.
I know, I saw that.
They have not submitted charge sheet against me, my lord. They stated, your lordship, what happened? If the charge sheet is not submitted 180 days, then the indefeasible right is violated, your lordship. They have never, the learned court below never informed me about my indefeasible right. I am covered with Thaluri Chakravarti and Lambadar Bagh, Supreme, my lord.
That you are right. Let us see. I will examine whether merely saying that charge sheet is deferred insofar as you are concerned, but in the charge sheet itself something is come on against you, then whether that date will be reckoned or not, that has to be seen.
My lord, in the brief fact of the charge sheet, they have mentioned my name, but they have not submitted charge sheet, your lordship. That is the point, my lord. If brief fact there is a name, then that is different. But they have to submit charge sheet against me.
That you, madam, you examine.
Whether
Because
they-
very specifically it says that charge sheet qua him is not filed.
Yes.
Insofar as the first preliminary charge sheet is concerned. So therefore, he says that if charge sheet is not filed, subsequent charge sheet is barred because of the delay. 167 to benefit will get. That is what we'll see.
My lordship rises, item 104 has been passed over. Your lordship place it any day if your lordship so desires.
He will adjust the date and give to all of you.
Interim
Just-
order need be accepted.
Yes.
Well, item 114, my lord.
Date may kindly be given within.